Jerry, can you tell us a little bit about your experience and how that is leading to the remarkable discoveries that you're making today?
As a result of a near fatal logging accident, I come to the realization that I only had one option. That was either to accept it or to do something about it. If I wanted it to be different, it was my responsibility to change my life.
I ran 2 races, a total of 500 miles in the Alaska wilderness with only 8 days of experience behind a dog team, and I didn't quit. So think of your goal, feel the passion come up inside of you, and forget about all the stuff on the side that's trying to convince you you can't do it. Yes, you can do it.
Hello. Just thought we'd start out the live with a little bit of Young Living propaganda. Felt like it was a good precursor to cross-examination. I'm DeeCee. I am an MLM dropout. I left Young Living in April of this year. And when Mombi sent us these transcripts, I was like, I'm incredibly excited to read these. And also, when we saw, or at least when I saw the little Spark Notes spoiler alerts on her stories about surgery without a medical license, pretending to be a doctor, intravenous whatever of essential oils, I was like, no way. And Young Living said yes way. And so we're reading these, and Kat has been joining me. I'm going to let her introduce
I don't know why you let me. Yeah, sounded really fun. So I'm also an anti-MLM content creator, YouTuber. I'm a registered dietitian. I was in another MLM, and it was nutrition related one. Technically, I was also in Young Living because I was trying to support a friend, and I did not know when I ordered the kit to support her that she signed me up to be a distributor. So yeah, there's that.
So we're both former Young Living brand partners. We're both going to be shocked on screen for you, not to be dramatic. I mean, I'm going to be dramatic, but that's just because I'm dramatic. I'm going to switch my camera so it doesn't look like I'm looking away from Kat on this stream. And okay. All right. Let me just double check I'm doing the echo cancellation. Hold on. I think we have a little bit of an echo.
Hey, y'all.
Kat, can you double check if you have the echo cancellation turned on your end?
Yes. Okay. Would it be in audio settings? Echo cancellation is on. Yep.
Okay. All right. Cool. I think it's something's picking up the audio, so I'm gonna see if I have everything closed down on my end. Close. Let's see. Save changes.
I have everything closed.
Okay, cool. All right. We'll just see what's happening. Okay. Great. Let me exit out and come back in because I'm still hearing an echo on my end. Hello, everybody. I'll be right back. I'm just gonna exit out and I'm gonna get right back in.
Is everybody hearing echo on my end while we wait? See if it's my problem, my fault. Because she has a nicer microphone than I do.
Okay. I think we should be good. We'll see.
Okay.
No echo. That's good. Great. I'm gonna go ahead and set my iPad up. Just a quick recap. Here's what's happened so far. In this case, they are arguing about contracts. Young Living said the people who started doTERRA broke their contracts and recruited people within Young Living who were big hitters in Young Living, and the doTERRA people said, heck no, we waited, we followed the rules. And in the process of opening statements, the defendants have thrown in a little bit of shade towards Gary Young, claiming that he was pretending to be a doctor and did some other stuff. And we've already done direct examination, which is Young Living's lawyer saying, interviewing Gary Young, so basically making Gary Young look the best, making Young Living look the best, making the defendants look the worst. And now cross-examination, which is that we're going to have 2 cross-examinations. There's 2 groups of defendants. So the first lawyer for the first group of defendants is going to cross-examine Gary Young. Then I think the second group of defendants lawyers is going to cross-examine Gary Young. And so Mr. Gary Young. Yes.
Gary Young.
Yes. And we've done a custom logo. So you can't really see the doTERRA's part, but Young Living's on one side and doTERRA's on the other side.
Yeah,
so
can we take a second to admire that? That's DeeCee's work, man.
So we're gonna, for all the
That's
streams
great.
going forward, we're gonna obviously have our little thumbnails, but we're gonna have a fun little background. That's a little bit of a dig at Young Living. So
Do you want to go through the comments, say hey?
Yep. Let's see. I'm gonna pull up my iPad and I'm gonna pull up this one. Let's see.
Happy anniversary, Elizabeth.
Yes. HTTP 192. That's it. Start mirroring. Start broadcast. It can't be reached. You can be reached. What's going on? Yes, we're up. Okay, great. All right, and we're going to be... I'm not going to talk to myself the whole time. Okay. Scroll up.
I don't want to interrupt you or bother you.
You're good. I'm the type of person that cannot walk and talk at the same time, so...
Yeah. Hello, Mommy. Dave's here.
Awesome, Dave. I was late to my own live stream. I'm so sorry.
Was me.
Oh no, it was no. I will take that. We were chatting in the back end. Okay.
Avery, hello.
Hope y'all all are doing so well. Oh, Gary, damn it, fingers, concentrate. Yeah, we're all just getting the bad karma from ragging on Young Living. I think they brought that upon themselves. So, just as a reminder, this is us, non-lawyers, just reading a transcript. We're gonna throw in our own opinions, maybe a little bit of snark. None of it's meant to disparage, bully, or hate. We have both been in Young Living, so some of the things, at least in my case, I think in Kat's case, it's going to be based on our experience. And yeah, so all of the things that cover us, that was listed before. So yes. I'm going to go ahead.
A lot of cringe, as Lori states.
Yes. Add to stream. Okay. And let me see if I can put this bigger.
Hello, Devastation. You're here.
Is that big enough for you to read, or do you need
Yes.
to make
Oh,
it
yeah,
bigger?
that's fine.
Okay.
That's good.
Okay. And who would you like to be, Kat? Do you want to be?
Oh, man. I feel like I always. I mean, what was I last time? Mr. Toth and Mr.
Oh
Smith.
yeah,
No,
I think I was. Yeah. So Mr. Toth is still
Toth.
coming up. Do you want me to be? Do you want me to be the? I don't even know, because Gary's going to be answering these questions. So was I Gary last time too?
I think so.
Okay, I'll be Gary again.
You do agree, Gary.
Oh, great.
I was asking the question.
The role I never knew that I thought I was going to play or that I would be good at. Oh,
Kind of missed some people.
So do you want to be? I'll be Mr. Smith, and
all right.
Well, yeah, and then you can be Mr. Toth in the court. Let me pull up the correct little side pieces. Mr. Smith, we are gonna have tabs on the side.
Oh no, Bailey.
Uh-oh.
So Bailey was in Young Living, and her sales rep kept trying to tell her that the oils could help her have a baby and prevent miscarriage. Then after the third one, blamed me for not using only oils for everything.
Oh my God. Are you serious? That's horrible.
So sorry.
I'm so sorry that happened to you. Oh my God. You just think things can't get worse, and then they do. Oh, I'm so sorry. Let me go ahead. I'm gonna flip myself around real quick again, because I'll just keep it like this. Okay. All right. Mr. Smith, so question, okay. This is Gary being interviewed again. I'm going to pivot. Kat, can you also be Mr. Smith? Because I would be talking to myself.
Yes. All right. So Mr. Smith, at one point in time, you sued Dr. Hill in this case, right?
Can you say that again?
At one point in time, you sued Dr. Hill in this case, right?
And so Mr. Toth objects. I'll be, yes. So, okay. Objection, relevance. And then the court said, I'm going to try to flip through these fast. So the court is the judge saying response. And then we're back to Mr. Smith. Yep.
Testimony about his foundation for opining upon execution of agreements. He couldn't testify in his deposition that Dr. Hill had signed one. He now says these two witnesses signed one or these two defendants.
All right. And then the judge says overruled. And then Mr. Smith said, I forgot to highlight that, but sorry.
You sued Dr. Hill?
Objection, form.
I will rephrase.
Oops. Okay. Rephrase. And then Mr. Toth, Mr. Young did not sue Dr. Hill.
Back to me, Mr. Smith. You caused Young Living to sue Dr. Hill?
That's Gary Young, IC.
Right.
I'm sorry. Could you? Oh my God. I'm sorry. Could you say it again? Gary, what are you doing, buddy?
Gary, pay attention.
I know. Good God.
What are we saying? What are we calling Gary?
Something.
Oh, man.
Comments are going wild already.
I know. I was trying to find it. Okay. Where are we?
I think we're on line 15.
15. Sure. You caused Young Living to sue Dr. Hill in this case, right?
I don't know that I did.
When your deposition was taken, you didn't think Dr. Hill was represented by me?
Objection. This is Mr. Toth. Objection, improper impeachment. And then the court said overruled. And so Gary Young, which is me, said, I'm not sure what you're asking. Oh my God, Gary.
When your deposition was taken in this case, did I represent Dr. Hill?
Mr. Toth said objection, lacks foundation. And then Gary Young said, I don't remember. Judge said overruled.
He needs some oil to remember.
I know. He needs whatever it's called. They have all these crazy names for stuff. Hold on. Sorry, I sneezed. I'm the witness, so I'm Gary. And we're just going to go back on Mr. Smith. Sorry. Gary Young, I don't remember that you did represent Dr. Hill at the time of deposition.
Do you remember me asking you questions about Dr. Hill's written agreement?
You asked a lot of questions.
Do you
Oh,
remember me asking you questions about Dr. Hill's written agreement?
I can't say that I specifically remember you asking about his written agreement.
Do you remember saying that you had no idea he had written an agreement with your company?
At one point in time, I didn't know that he did have an agreement. That is true.
So with these defendants, Miss Shepherd, isn't it true that you had no idea Miss Shepherd had an agreement with your company either, except maybe your attorneys told you?
No, that's not true.
How do you know Miss Shepherd had an agreement? You weren't in that department, right?
Mr. Toth, objection, Your Honor. And then me, Gary Young, said it was my job. The court said, wait, there's an objection. So me, Gary Young, should have shut my mouth and been quiet so the court could have ruled. And then Mr. Toth said, objection, Your Honor. These are stipulated facts about Miss Shepherd's agreement. Mr. Smith.
Foundation of this witness, Your Honor. Witness can't testify that there's an agreement if he doesn't know it.
All right. And so the judge said, I'll allow it. And so we're back to Mr. Smith.
How do you know Miss Shepherd had an agreement?
Because the chief operating officer of the company, the attorney of the company, discussed it with me.
Okay. So someone told you before you came and testified that they had an agreement. Is that right?
Yes.
And would that be the same with Mr. Harrison? Someone told you he had an agreement and that's why you're here today?
No, that's not why I'm here.
Well, then what are you doing here? That testimony, someone told you that Mr. Harrison had an agreement, and that's why you testified he had an agreement because someone told you.
No.
You weren't in the apartment when Mr. Harrison was given his agreements, right? You weren't there?
Was I there physically when he was given his agreement?
Yes. That's a start.
No.
You didn't see the written agreement while he was employed there. You never saw his employment file?
Yes, I did.
You saw his agreement while he was employed there?
Yes.
How did you do that? Why didn't you tell the jury?
The attorney showed me the employment agreements of all. The attorney showed me the employment agreements of almost every employer that came to work for Young Living on the upper level. I think he meant employee.
Yeah, you mean employee? You said employer.
Sorry, I'm like, wait, let her keep reading. Oh my god. Oh, Gary Young's making me so mad already. Oh my god. You see what he's doing? He's being very like, I'm not gonna say cagey. He's just not answering the questions, which I guess that's a good.
Not being forthcoming.
Yeah. Oh my god. Employee. I'm sorry. Yeah.
So you're saying at some point in time, the attorney at the company showed you the employee files of various employees?
Yes, we talked about it.
That was a yes. The attorney showed you
yes
employee files. And when that they showed you these employee files, and when was that they showed you these employee files?
Yeah. I don't remember.
And that attorney didn't show you Dr. Hill's files, apparently, right?
I wasn't living in Utah at the time that Dr. Hill moved his employment to Young Living from the Springville clinic.
So that's the reason why you say you didn't see his file. Is that the case?
Most likely.
Well, again, I want the jury to understand. He was employed at Young Living between 2003 and at least 2007. Is that correct?
Yes, I believe so.
And during that time period, you never saw Dr. Hill's employee file?
I don't remember. Oh my god.
But you do remember seeing Miss Shepherd's employee file during that same time period?
Yes.
And the same answer for Mr. Hill, the same answer for Mr. Harrison?
Yes.
Now, this idea that I take it you would agree that distributors are the lifeblood of the company?
Yes.
That's what your attorney said in opening. Do you agree with that?
Yes.
And when the distributors learn about things about the company that are negative, they have a tendency to want to leave, correct?
Mr. Toth, objection. And then me, Gary Young, depends on the facts. Mr. Smith?
Notice he said depends on the facts, not on the...
He's so sassy. Oh my god.
Depends on what the truth that they know is.
Yep. So, Mr. Smith, I think you said, and then the court said, what's the objection? Mr. Toth, the objection is vague, it's overbroad, it's non-specific. So the judge said, I'll have you rephrase. And back to Mr. Smith.
You testified a moment ago that all distributors come and go. They always do. Is that accurate?
Yes. And then Mr. Toth, gosh darn it. Objection mischaracterizes his testimony, and the judge overruled the objection. And so Mr. Smith,
the answer is yes, Your Honor.
And the judge said it was. And then back to Mr. Smith.
And when you say distributors always come and go, in 2007, when Mr. Sterling was no longer with your company, the company was governed by a set of policies and procedures, correct?
Yes.
And that policies and procedures governed the relationship with the company and each distributor, correct?
Yes.
And that policies and procedures allowed each distributor to go at any time they wanted?
They're an independent person.
You say they were independent?
Yes.
That meant they could come and go as they wanted to?
They can.
And the company also had policies and procedures that allowed the same distributor to have competing businesses in two different MLMs, right?
Yes.
So in 2007, if I was a distributor with Young Living, I could, if I wanted to, be a distributor with doTERRA and a distributor with Young Living, correct?
Yes.
Did that ever change?
No.
You always have allowed your distributors to be both distributors in Young Living and doTERRA if they wish. Is that correct?
Yes.
Didn't you in August of 2008 change your policies and procedures to eliminate the ability for your distributors to be both distributors at Young Living and doTERRA?
Okay, Mr. Toth coming in with an objection. Objection, foundation. The judge sustained that objection. And then Mr. Smith.
Didn't the company in 2008, with your consent, change the policies and procedures of Young Living so that you could no longer be a distributor in both Young Living and doTERRA?
Mr. Toth, same objections, Your Honor. That's not foundation. That's not foundation. That's not foundation, Your Honor. Okay. Judge, let's lay some foundation. So, Mr. Smith.
Are you aware of a change in the policies and procedures in 2008?
There were changes made, but there was more to do than that.
You authorize and approve every change, correct, in the policies and procedures?
Pretty much every change.
So in the policies and procedures, if there was a change in 2008, it was one that you authorized, correct?
Yes.
And in 2008, isn't it true that the policies and procedures changed at the company, eliminating the possibility of your distributors to be both a distributor at doTERRA and Young Living?
This is me, Gary Young. Your Honor, there was more to that than what he's asking.
That's such a simple question.
I know. That will have to come out with your attorney. I'll have you just answer the question that's been asked. So me, Gary. Yes. I'm guessing he's answering yes to Mr. Smith.
So a moment ago, when you said that it's always been your company's policy that distributors could sell for both Young Living and doTERRA, that would not be accurate after August of 2008, correct?
No, it's a misleading question because to this day, we still have distributors that sponsor in other companies.
Not other companies, doTERRA. My question to you was specifically doTERRA. My question to you was specifically doTERRA. Isn't it true after August of 2008, contrary to your earlier testimony, you have prohibited your distributors to be both distributors at Young Living and doTERRA?
Yes, because they were soliciting other distributors. And then you're going to object to me. Great. Love to see it.
I was like, is that a objection after the term yes? Non-responsive to the question. Move to strike.
Sustained.
Whose contract came first at Young Living? Can you tell the jury which contract got signed first?
David Sterling's contract, I believe, was signed first.
Mr. Sterling's contract, that was negotiated by you?
No.
Let me see if I get this right. He was at your company working in a position other than the COO, and you decided to elevate him to the COO position. Is that correct?
Yes.
And your testimony to this is you did not negotiate any of those terms with Mr. Sterling for his new contract when he got it. Is that correct?
No, the legal department did.
So you didn't, let's make this clear. All of his compensation terms in that agreement, you negotiated none of them?
Oh, we discussed it, but I didn't negotiate it.
So he gave you the terms or you gave him the terms? How did that work to get a written document?
The terms were given to Mr. Sterling
By you?
by our legal department.
So again, I'm a little confused. Usually when you get an agreement, it doesn't come from the terms. Somebody agrees to the terms. Did you negotiate the terms with Mr. Sterling?
We sat and talked about it. My legal team are the ones that did the final negotiation and writing of the contract.
You negotiated some of the terms with Mr. Sterling, apparently?
We talked about a salary, benefits.
So when was that you negotiated? What was that time period?
I don't remember.
Would that have been, do you know when that contract was signed that he signed?
I don't remember now.
I think we displayed it in the opening. Will you accept like 2004 as begin of the date and being a good date since I don't have the date in front of me?
Could be.
Do you think it's some other date than 2004?
Objection, asked and answered, and then Gary Young's being a brat. I wasn't in the opening, and the court said overruled, and we're back to Mr. Smith.
I'm just asking you not whether you're in the opening. Do you think that the contract was signed between Young Living and Mr. Sterling in 2004?
I can only assume because I don't have not seen the date.
And you have no memory?
Of the date?
Yes. That you got this new COO at the company. You don't remember?
No, I don't remember the date.
You don't remember the year, right?
Oh my God, it's like who's on first? Oh, okay, sorry. No, 2003, 2004, I'm not sure.
Let's see if I can get, what exhibit number? 9. If you look at the screen, I'm showing you what's been marked as exhibit number 9. It's the...
Mr. Smith, we're not seeing that exhibit yet. Hold on a minute.
It's not happening?
Now it's coming up here too. I was trying to tell Mr. Smith we're not seeing it here.
I don't have it yet.
Yep. And then I wanted to make sure the witness didn't see it and started talking about an exhibit before we're seeing it.
Is it there yet? Oh yeah, me. You recognize exhibit number 9?
Yeah.
That's a yes?
Yes.
And what is it?
Your Honor, we're going to object to this line of questioning. This was discussed in our motion in limine. Well, okay, limine or limine. There's like different pronunciations. I'm going to say limine, but in Texas, I think it's pronounced limine. Like there's a difference between voir dire and in Texas, they call it voir dire. So I'm just letting y'all know. This was discussed in our motion in limine. Before we get too far down this road, we'd actually like to approach on this. The judge said, come on up. Sidebar discussion that they're not going to say. And then we're back to Mr. Toth, who said, Mr. Smith, I apologize. I withdraw that objection. Thought it was a different document, Your Honor. And back to Mr. Smith.
I don't have a copy up here, so I didn't see it. The agreement you see in front of you, you recognize that as the agreement between Young Living and Mr. Sterling?
Yes.
Is that your signature on the document?
I'm not seeing a signature on this document.
Sir, you'll have to turn to page 4. Sorry. I forget you don't have the set in front of you. If I don't tell her to turn it, you won't see it. Is that yours?
Yes, that's my signature.
This is dated 2004. Do you see the date up there, April?
Uh-huh. Affirmative.
Does that refresh your memory, that Mr. Sterling became COO of the company in 2004?
Yes.
Now, in 2003, between 2003 and 2004, the policies and procedures of the company had not changed, right? They did not change until 2008, correct?
I don't recall.
You don't remember one way or the other?
No.
When this agreement was signed, you signed it on behalf of Young Living, correct?
Yes.
Were you familiar with its terms before you signed it?
Yes.
You see there in section 10 that it says, quote, "This is a complete agreement," end quote.
Can't see it.
Can you turn to page number 3?
Okay.
Do you see that?
Yeah.
And in section 11, right below that, you see where it says it can only be changed in writing.
Yes.
You never changed that agreement, correct?
Not to my knowledge.
You knew that this contract would govern the post-employment obligations of Mr. Sterling, correct?
Oh my God. I'm not understanding your question. I'm sorry.
Sure. You knew this contract was the one and only contract that would govern any obligations of Mr. Sterling after you fired him, right?
Yes, I believe so.
And in fact, you fired him on August 8th, 2007 at your offices, correct?
That is not correct.
On August 8th, 2007, you had a meeting at your offices where you had your wife, an attorney, I think Mr. Bentley, Emily Wright, and David Sterling in a room. Do you remember that?
Yes.
Was there anyone else besides those people that were present?
I don't remember.
While in that room, you instructed someone to go to David Sterling's office and clean his office out, correct?
No, that is not correct.
You told someone to go pack his stuff up and leave it in boxes at the curb.
That is not correct.
So if someone were to testify that his office was packed up and boxes were at the curb, that would not have been as of a result of direction from you, correct?
That would have been a direction from somebody else if that took place.
Did you tell anyone to go move the boxes back into his office?
No.
At that meeting, you told him he was fired and had to leave.
That is incorrect.
You gave him a writing that told him you were fired and you were not allowed to re-enter the building, right?
That was not correct.
Let me have your attention to Exhibit 10. Do you see Exhibit 10 in front of you? It's a letter dated August 16, 2007. Do you see that?
Yes, I see that.
Now, that's dated 8 days after this meeting, correct? The meeting you just described a moment ago?
Yes.
So this letter was drafted with your lawyer's help 8 days after you met with Dr. Sterling. Correct?
Yes.
And this letter is signed by you?
I need to see the next page.
Yes, please turn to the next page.
Yes, that's my signature.
I'd move Exhibit 10 into evidence.
So then the court says, any objection? Mr. Toss says, no objection, Your Honor. Court says, received.
If I may
Mr.
display it?
Yep. And then judge says yes. And then we're back to Mr. Smith. Before you continue reading, I just want to catch up on the comments because there's 63 that came through.
Oh my goodness.
Oh my gosh. Everybody, it is a little difficult to put stuff on the screen. We actually may wrangle someone to be on the back end for the next live stream so they can pop up the stuff on the screen.
We're going, back and forth and back and forth.
Yeah, it's almost too fast. Yeah, it does a live chat. It sounds like Gary Young is being if not, maybe not evasive. Maybe you have to be evasive when you're doing the law stuff. I don't know, but he's being very like, I don't know what the right term is. It doesn't sound like he's telling the truth, or he's being so stubborn about giving up any kind of information. Maybe you have to do that as a witness, but it doesn't. When I'm reading this, I'm like, oh, come on. And then he's
not trying.
Like, yeah. Yes.
To clear it.
I'm glad you love readings like this. we're doing our best. Oh, turn to page 394. Yes. Yes, Avery. Oh my gosh. Oh.
This guy is making Mr. Jones look like a truth sayer.
Yes. Yep. And then he's definitely being evasive. I'm glad it's not just us that are picking up that vibe for sure. Let's see.
what was it? Drake and Josh, that quote where I think it was like, "Are you calling me a liar?" And Josh was like, "Well, I'm not calling you a truther." I think that's what it
Yes.
was.
Oh my gosh, that's the perfect quote for this. That is the perfect quote. Yeah, it really did sound like when Gary Young's going back and forth with Mr. Smith. It's like, who's on first, what's on second. It was that kind of vibe. Reading it, and it's like, oh my gosh, Gary, what are you doing, buddy? Oh my goodness. Yes, yeah. Yeah. It is funny. It's funny. MLM specialized in evasion. Yeah, it for sure does. And again, we heard Gary Young in direct examination from his lawyer where he was saying like he is the board member, the CEO on and off, he's the founder, he's involved in all aspects of Young Living, and then in this exchange it's like, "Oh, I didn't see it. I don't know. I have no idea. And it's like, "Do you have no idea? Give me a break." Reminds me of I never inhaled. Yep, sure does. Technical term is a bullshitta artist.
It's all the oils coming to his head.
Yes. He's literally been sniffing too many essential oils. Oh my God. Okay. Let me take a drink and we'll get back to it because we're about to do more stuff.
Yay. Did he call him a doctor? I'm not sure. That might have been me misreading it.
I think it was Mr. I think it was just us going back and forth. The lines are kind of close together. So not as close together as I think there's like a 40-line document. So we're blessed that this is only 25 lines. So it's a good time. Okay. We're back. Were you reading or were you on the next?
14. I'm on 14.
Okay, perfect.
On the first page, it says, quote, "On August 8th, 2007, I gave you notice of termination of your employment," end quote. Is that accurate? In other words, did you give him notice of termination of his employment on that day? Yes or no?
My direction with Mr. Sterling was I placed him on administrative leave on August 8th or August 7th, whatever it was, due to investigation.
So let me see. What you'd now say was said by you in that meeting was not the words, quote, "termination," end quote, right?
In that meeting, no.
You said, quote, "leave," end quote.
Yes.
Then I asked myself why in this letter that you had the chance to have your letter, your lawyer look at before you sent it out. Why did you say, quote, "On August 8th, I gave you notice of termination of your employment," end quote. And then it goes on, quote, "and I gave you the opportunity to resign," end quote. Why would you say that if you didn't really fire him? Why?
I don't remember the details now. Well, how convenient, Gary. How freaking convenient.
Been a long time since that happened, right?
It has.
Why did you wait until 2012 to sue after everyone's memories fade?
Oh, Mr. Toth with the objection. I'm not ready. I'm unprepared. Oh my God. Okay. Mr. Toth, objection, Your Honor, relevance. We've been down this before. The judge said response, Mr. Smith.
It's relevant as to why they waited to sue because it goes to all kinds of issues, including fading of memory and what the purpose for writing and was and delay.
None of these, Mr. Toth, none of these are elements of any cause of action or any defense in this case, Your Honor. Mr.
Goes
Smith.
to memory.
Okay. So judge is sustaining the objection from Young Living's attorney. And so now we're back to Mr. Smith.
On August 8th, did you hand Mr. Sterling a termination letter?
No.
Let me turn your attention to exhibit number 1159. It's a letter dated August 8th, 2007, addressed to David Sterling. Did you give that letter to David Sterling?
No.
On August 8th, 2007?
No.
If he testifies you gave that letter to him, would he be lying?
Yes. David Sterling knows the condition of his departure.
Objection. Non-response to the question.
Okay. The court says if you'll answer the question that's been asked, please.
Were you saying that letter, even though it has your name on it and the date of August 8th, was not drafted by you?
No.
You never have seen it?
It wasn't signed.
That doesn't mean you haven't seen it. Have you seen it?
I don't recall seeing this.
Did you cause this to be prepared?
Not to my knowledge.
Isn't it true that you told him at the meeting that all of his job duties were terminated? He was relieved of all of his job duties effective immediately?
Oh my God, I don't remember the details of the conversation.
Excuse me one moment, Your Honor. Your Honor. I would move 1159 in. It was stipulated.
Was there stipulation on 1159? Then Mr. Toss said, there is, Your Honor. So then the judge said, all right. So I have a motion to receive it. Is that right?
Yes, Your Honor.
And then the judge says, proceed.
Display 1159. This letter that says, quote, notice of termination, end quote, and the quote, you are, however, relieved of all active job duties effective immediately, end quote, was not written by you or Young Living. Is that what you're telling this jury?
I'm not sure I'm looking. Oh my God. I'm not sure I'm looking at the same letter.
It should be. It's displayed on the same screen, I think. It looks the same to me.
Which paragraph?
Second sentence down. Quote, you are, however, relieved of all active job duties effective immediately, end quote. That you're saying was not written by you or your company, correct?
That was not written by me.
It's got your signature line down below. That wasn't something you gave Mr. Sterling at the firing of him?
No.
On August 8th? No. How about this in the third paragraph where you said, quote, I want to remind you of your continuing obligations regarding solicitation. Was that something you recall telling him when you fired him on August 8th, 2007?
No, I don't recall that conversation in that detail.
You don't know, as you sit here today, how this document came to be. Is that correct?
That would have been typed by the legal department.
Typed by the legal department at Young Living?
Yes.
Now, this letter right down here said to him, quote, in addition, you agreed not to solicit certain individuals, end quote. Did you see that letter? It's in the third paragraph, fourth line down in the third paragraph.
Okay.
Do you see that sentence?
Yes.
Do you remember that topic being discussed when he was fired on August 8, 2007?
There was a lot of things that were discussed in that board meeting.
Why that? Was that
I can't remember in detail if that was.
because of the passage of time?
10 years.
Did you tell him that you had already filed a lawsuit against him?
No, because one hadn't been.
Wouldn't that be something that you would have said, right?
Nope. I mean, no, sorry. No.
Do you think it's good for an employer like yourself to tell your employee that you've already filed a lawsuit against them?
Mr. Toth,
When you
objection.
fired them?
Mr. Toth, objection, form and foundation. He has no.
It goes to the issue of the loving environment in which these people work. It is a practice at Young Living when they fire people to say, I've already filed a lawsuit against you.
The judge
Is
said,
it?
oh, yeah.
Is it? Not it is practice. Is it practice?
Okay, the judge says, I'll allow it, go ahead. Then Gary says no, and then we're back to Mr. Smith.
But you did do that to Mr. Sterling, though, right?
No.
You wrote him a letter and said an email, quote, I've already filed a lawsuit against you, end quote.
Not on August 8th.
When did you do that? August 9th?
I don't remember. Oh, geez, Mr. Gaylord. And so Mr. Gaylord says should be 1160.
I don't think so. If it is, I don't have it. Let me turn your attention to Exhibit 1160. No, I don't think that's it either. Is it on this page? I'll come back to 1160 in a second. Let me turn your attention to Exhibit 1021. At this meeting on August 8th, you tried to set up a kind of like what we would call a moot court, right? You wanted to have a trial of Mr. Sterling, right?
No.
You presented evidence against him as to why you should fire him, correct?
What day are you referring to?
The day you fired him, August 8th, 2007.
Dear God, I didn't fire him on August 8th.
Let's call it the moot court, where the letter that said, quote, notice of termination, end quote, was prepared by your legal office was given to him.
Okay, sorry, I missed some highlights. Sorry. Oops, not yellow, purple. Sorry. User error. Okay. Mr. Toth. Object to the characterization of the document and his testimony, Your Honor. He hasn't used the term moot court. Mr. Smith keeps saying that over and over. The court said it's proper cross. I'll allow it. Go ahead.
The
Mr.
day
Smith.
I'm talking is the day you just identified for the jury. The letter was prepared by your attorneys at your company, dated August 8th, that said, quote, notice of termination, end quote. That day, did you have a moot court hearing?
No.
Did you present him charges which were against him?
We had a board meeting.
That wasn't my question. Did you present charges against him?
There's a difference between charges and allegations.
Okay, my question was charges. Let's use that term. Did you present charges against him?
My term is no. Oh my God. Holy crap.
Okay.
Oh my God. Sorry. Did I hear that right? Sterling was fired. The story we got over at doTERRA is that the executive team Hill Sterling. Oh. Yeah. So they all they either left or got terminated. In this, we've read 212 pages so far. And there's some backstory in the first video we made. I think it's called episode 1. It's in a playlist on my channel, and I think Kat is probably going to put it in a playlist on her channel too. So we read that. There's a little bit of backstory. I think they were fired, or I know Sterling was fired, or he believes he was fired, and so I'm sure doTERRA is telling a different story, and Young Living's telling a different story, and we're trying to find out what the hell's going on. Oh my God.
Okay. I take it, if I were to phrase that as, quote, allegations, end quote, your answer would have been yes. Did you give him allegations?
Yes.
Did you present to him that which has been marked as exhibit 1021 that's already in front of him? Did you give him that document? Did you give him that?
I'm going to say I probably did. I don't remember.
I'd move exhibit 1021 in.
Mr. Toth, Your Honor, we'd object to relevance. There is the reasons Mr. Sterling left Young Living or was terminated from Young Living is absolutely relevant to whether or not he's breached his solicitation agreement. And the court said response. Yep.
Goes first to impeachment, first line. Second line, impeachment. Third line, they've already indicated why they hired him and what his import was. And this issue of termination is at issue and the date.
Mr. Toth, and then judge just said overruled. Okay.
Move it into evidence, Your Honor.
Okay, I'll receive it. And we're back to Mr. Smith.
May I have it displayed? Now, you said you didn't use the term, quote, allegations, end quote. But do you think that these irreparable charges were used by you in giving it to Mr. Sterling on the day you terminated him, correct?
Yes, that's what it says.
Now, a moment ago, you said you never used the word, quote, charges, end quote. But this in writing says you use the word, quote, charges, end quote. Would you like to change that testimony?
In writing, as stated, I did not write that.
Well, when it says right there, I asked you if when you fired people, if you told them you already filed a lawsuit against them. You said no. Does that first sentence refresh your memory? Attorney has been hired, a lawsuit currently pending. Is that kind of typical firing from the family?
That was not on August 8th.
When do you think?
Is there a date on it?
These irreparable, right? I don't know why I can't.
Irreparable.
Yeah. Irreparable. There, I was like, that is not right. These irreparable charges were given to Mr. Sterling after you had already fired him. Is that what you think? Answer the question, please.
I don't know how many times I need to say it. I didn't fire him on August 8th.
Let's stick with that date. You think you gave him these, oh my gosh, stop using this word. I can't.
Irreparable.
Irreparable charges. You think you gave you these irreparable charges to him after August 8th?
I'm assuming they were after August 8th because it did not happen on August 8th.
You think after August 8th, you caused this to be given to him in some other fashion, either by handling it to him or by email, correct?
God, I don't remember.
Let's be clear to the jury. After you told him to leave and never come back, he never came back, correct?
No.
You never saw him again, right?
No.
When you say, quote, no, end quote, and I ask, quote, right, end quote, I want to make sure he never came back, correct?
Correct.
Thank you. So it wasn't in a personal meeting between August 8th and some other date. You didn't give this to him on some other date, fair?
I don't know.
You didn't email it to him, fair? You didn't meet with him. You didn't email it to him, fair?
I can only assume that it wasn't. I know that it wasn't given to him on August 8th.
Well, again, you didn't give it to him in person and you did not email it to him, right?
I don't know. I emailed Mr. Sterling letters explaining circumstances. This is one I don't remember.
Okay. When you said up in the top there, quote, attorney has been hired, a lawsuit currently pending, end quote, that was false, right?
On what date? Oh my God.
Well, are you saying you gave this to him after you filed the lawsuit in June of 2012 or before that date?
It was before that date.
So whenever you gave it before June of 2012, that was the lie, right? There was no lawsuit pending?
It was an investigation.
You said a lawsuit was pending. There was no lawsuit pending, correct?
There had not been one filed. That is correct.
And under item 9 on that list, you said you fired him for interfering with Gary Young's directives to the marketing department, correct?
That's what it says.
And that's what you told him at the meeting on August 8th. One of the reasons you were dissatisfied with his service was because he interfered with your directives to the marketing department, fair?
That is correct.
And the directive to the marketing department that he interfered with is you wanted to make a claim of seed to seal, that your company had all of these farms and that you were making all of this oil and that you did not buy it on the market. You wanted to tell everyone on this new marketing campaign, Seed to Seal. And he, as the CEO, knew that was an absolute lie and said that he did not want to be part of that Seed to Seal program, right?
Not true, but also holy shit.
What?
Oh my God.
Sir,
Whoa.
your Seed to Seal, that's a false advertising claim that you continue to pursue with your company, correct?
Okay, hold on. Mr. Toth's coming in here. Mr. Toth, Your Honor, I'm going to object again. First of all, we are way off on relevancy. This doesn't have anything to do with the date he was terminated. This is now just becoming a series of speeches by Mr. Smith about what he wants the evidence to be and confronted the witness with it. Judge said the objection is relevance. Response?
He raised the issue. He asked where the farms are, how many farms there were, why the farms were there, what they raised the farms for. The termination was in part for the farms. My witness is going to testify I was terminated because of the Seed to Seal program, which is a Seed to Seal program. My witness is going to testify I was terminated because of the Seed to Seal program is an absolute lie.
Oh my God. What? Okay, sorry. I'm shocked. I can't
we need sound effects or something.
I don't even know.
Oh my God! I don't even know what to say. I'm shocked right now.
Oh, I don't even know what's the there's not even good like I don't even know. I don't even have any good sound effects. I'm shocked. Live chat. What the hell? Thanks to Mommy, it's been leaked. Yes, literally, Mommy is like doing the most against Young Living. Yeah, this is not hilarious, but it's eye opening because one, the defendants are getting all this stuff into these transcripts, and again, we're obviously reading them. But if they got fired because someone found out that Seed to Seal was like not a thing, like that's a huge deal. I mean, they've laid their entire foundation of their company on the fact that they have Seed to Seal for every single oil. So, oh my gosh.
I heard about that Seed to Seal before, like even before I got that little pack.
Yeah.
They
say it's better than organic. That's what they claim in all of their literature, that it's better than organic. So, okay, I derailed us. Okay, so where are we? Mr. Toth said, Your Honor, and then
he raised the door.
Yep, and then Mr. Toth comes back. You don't open the door by saying the word farm. Oh my God. All that was a simple introduction to the fact that the company owns farms, and it is part of their entire process. It has nothing to do with marketing, didn't have anything to do with this document, and it's not relevant. And we've now spent 10 or 15 minutes going over different things that are said in this document that have nothing to do with Mr. Sterling's non-solicitation clause.
The witness testified that his company grew a majority of their oils to you and this jury just a moment ago. That is a lie, and I plan on impeaching him.
Oh my God. It's proper impeachment. Overruled.
That's a lie. That's a lie. You don't grow a majority of your oils, do you, sir?
Holy shit. I'm sorry, I'm cussing. I'm sorry.
Gary said.
Oh, I don't know the exact percentages, but I know we grow a big percentage of our oils.
So that's not all of them. When you told the jury your company grew a majority, would that mean more than 51%? That would mean more than 51%, right?
That would be correct.
And that's a lie.
Oh, I don't believe it is.
When you had confrontations with your management, who was Emily Wright and David Sterling at the time, they refused to participate in your claimed Seed to Seal because you did not grow the oil that you were claiming publicly.
That is false.
And since then, up to today, when you told this jury a moment ago, you continue to sell a majority of your oils. That is now especially untrue because of the amount of oil you sell, right? You've grown in size by 10 or 12 times, correct?
Yes, that is correct.
And you haven't bought 10 or 12 as many farms, right?
From the day before?
From the day that they were there in 2007 to current, there aren't 10 or 12 times as much farms bought by Young Living.
No.
There's now 10 or 12 times as much oil sold without replacing it, correct?
Not correct.
You said you had 4 million distributors. That is misleading, correct?
Sorry, I just got distracted. My brain is breaking right now.
Right.
That is on our books.
On our books, meaning at some point in time since you started the company in 1991, there were 4 million on your books.
I'm assuming that's correct.
And your company's policy is that if they don't buy anything over a period of time, is it that they're no longer considered an active distributor? 6 months, a year?
I think it's 1 year.
1 year?
Yeah.
And how many of those 4 million haven't bought product in the last 1 year?
I don't know.
How many active distributors does your company have?
I would say probably monthly active 1.5 million.
Why would you want to tell the jury that you had 4 million distributors when you only really have 1.5 million?
Because I was asked how many distributors we have. That's how many is on our books.
when that would be like someone being like, how many employees do you have? And then counting every single employee that you've had since
since the beginning of time.
Yeah.
That no longer work there.
Who responds like that?
Gary Young does. Gosh darn it. Literally, Gary, damn it. Just answer the freaking question. Oh my gosh.
When this contract was signed by Mr. Sterling, you knew, as we've talked about these distributors, that these distributors could move from your company to any other company, correct? All those questions about the policies and procedures, to the best of your knowledge, were in place when the contract with Mr. Sterling was signed, correct?
Yes.
And you knew that the personal volume, the requirement for your company at the time to be eligible for commissions, was $100 per month, correct?
You know that's correct, Gary Young. Oh my God. I believe that's correct. Oh my God. I'm so mad right now. He knows that's correct. He wrote all this shit. Oh my God. I'm sorry. Live chat. I'm sorry for cussing. He's making me, he's not making me mad. I'm mad at Gary Young. I'm actively mad at an RIP. I don't know. I'm so sorry. I'm just so mad. Oh, he knows that's right.
And you didn't know Gina Truman, correct?
Yes, I did.
You did?
Yes, I did.
How did you know her?
She's a member and she's a very close friend of my wife.
And your wife handed out anti-religious literature to the Washington Convention in September 2007?
Absolutely false.
Did you see anti-religious literature that your wife had with her at the convention?
No, absolutely false.
The question was...
The answer is no.
Were you with your wife every moment at the convention?
Of course not.
Would you agree, if your wife was handing out anti-religious literature to its distributors, that may have a negative impact if that distributor wants to stay with the company, correct?
Mr. Toth, objection form calls for speculation. Gary Young, that's possible. Judge overruled. We're back to Mr. Smith.
Have you instructed other people not to promote the religion at these conventions?
That is our policy.
And the reason is promotion of religion has a tendency to turn some people off?
That's correct.
But you, at these meetings, you kind of have a kind of religious overtone in your presentations. Fair?
No.
Give me a break, Gary. Yes,
Gary, tell the truth.
Don't lie.
Literally, there's so much. There's literally so much. I mean, have you ever watched one before?
Lying is wrong. Yeah.
Lying's wrong.
Yeah. Mm-hmm.
Oh my God.
Well, have you ever stood on the stage and while you're doing your presentation say, I think I need to ask my father, and then you'd pause for a moment and then you'd say, my father wants me to do this? Have you ever said that on stage?
Holy crap. No.
Did you ever tell anyone that you had a special oil that could cure homosexuality?
Oh my God. I'm sorry, he didn't say that. No. Mr. Toth. Mr. Toth, sorry. Wait, where am I? Okay. Mr. Toth, Your Honor, I'm going to object. Can we have a sidebar? Judge says yes. The sidebar discussion has been had. The court says, why don't we have a recess for, say, 10 minutes? We can reconvene. It's about 3:30, so 3:40, we can reconvene. Okay, we need to look at the comments real quick. Okay, take a comment break. Oh my God.
Mombi shared that part on
Yeah.
Instagram.
Oh my gosh. And yeah, Mombi has like all of the juicy bits in her stories.
Mm-hmm.
I'm just getting a lot of messages. Oh my gosh. Yeah, he's very he has done stuff like that on his conventions and stuff. And he's saying, I can't stand the nasty fake POS, even though he's dead still. Yeah,
That's how I feel.
Yep. Distributor, employee, pledge, donate. Yes, exactly, Dave. It's literally Amber Heard, but man. Oh my gosh. Oh my gosh. My brain is breaking too. Yeah, we literally do not know what's I expected maybe like the transcripts to read a certain way. I didn't expect Gary to be this slippery.
Yeah.
Just evasive. lying, I don't know.
I mean, but it kind of fits in with character-wise.
Yeah, I mean, you
Between the
look at his
two.
history and it maybe doesn't surprise, but it's just,
Mm-mm.
hey, Kat, can you believe this? Can anybody in the live chat believe this right now? Because we're shocked and we're reading it. Yeah. Oh, and there's 2 story highlights now on Mommy's page. Oh my
There's
god.
so much juiciness.
Yeah. It's oh my gosh. All right, we're back from our recess, and we need to put the little tabs back up. I think Mr.
Thank
Smith is up.
you, Your Honor. All right.
The jury left the courtroom. Recess taken at 3:25, resuming at 3:41. And then the judge said, "Thank you. You may be seated." We're back on the record, and there was an objection on the table when I left. I think you have a rule or something you wanted me to look at. Is that right?
Yes, Your Honor. Yes, Your Honor. It's Rule 613B. It provides under extrinsic evidence of a prior inconsistent statement that the witness has to be first examined and given the opportunity to explain or deny it before I ask Mr. or Miss Meredith. The issue is simply the question pending was, did you tell people that you could cure their homosexuality? It's either yes or no. Jan Meredith will come in and say that's, in fact, what he said. One of the reasons why she left.
Oh my God. Mr. Toth, Your Honor, the response to that is it's not a prior inconsistent statement because it's not an inconsistent statement made by Mr. Young. It's conflicting testimony. Let's assume that's what Miss Meredith is going to say. That's simply her testimony versus Mr. Young's testimony. And if they want to call Mr. Young in their case after Miss Meredith testifies that to question him about that, they're welcome to do that. That doesn't set up prior inconsistent testimony. There's no evidence that he made a statement. They're simply pulling out of the air saying, did you ever say this? The real risk is this is really an attempt to walk into all sorts of, as we've talked about before, unmoored, untethered information that's highly prejudicial. It's highly inflammatory. We understand that. It distracts the jury from what they're supposed to be looking at. It doesn't even impact credibility. Oh my God, come on. It does. Okay, sorry. Because of its risk and because of its danger of prejudicing the jury, it's not an inconsistent statement in that way. That's why we're objecting to it. That's why we're so concerned about it being used like this. Potentially, you could simply ask Mr. Young about any kind of thing you make up out of thin air and see if a witness will testify about it. They could go on forever asking him all sorts of questions about anything they want to ask Mr. Young about from his past that's true or not true, and then see if anyone else is ever going to ask about it. What will have happened by them doing that, Your Honor, and they will have vitiated, I don't even know. Alexa, how do you pronounce Vitiated? Sorry for setting up y'all's. Vitiated? Okay, sorry. And they will have vitiated the protections of Rule 403, which is now the jury believes that there is arguably a good faith basis for asking all these questions. And then the court has Mr. Young previously denied making a statement in deposition. Was this a question that was posed to him?
I believe Miss Meredith. So,
yeah.
No, not yet. 613A is on that subject, which is first, it doesn't have to be inconsistent yet. I'm examining him under 613A, which is not yet inconsistent. It's a prior statement. The prior statement having been made by Jan Meredith. Jan Meredith says, he told me those statements. I was very uncomfortable, and that's why I wanted to leave Young Living. I just asked him, did you make those statements? He can either say yes or no. And if he says no, then Jan Meredith can come in and say he made those statements to me. That's all this is about, why she left. They're suing because Jan Meredith left. If Jan Meredith left because he made that statement, that seems to be totally appropriate for this case.
Okay, and then Mr. Gaylord speaks up. He is the attorney for the second group of defendants. He said, quick weigh-in because I'm going to add Greg Anderson to that. Greg Anderson was at the Washington, D.C. convention when those things were said. He's testified to that same fact. They're going to come in and testify about what was said during that convention. That's fair game. And then Mr. Toth said, as you pointed out, Your Honor, Mr. Young has never testified under oath one way or the other about those statements. Okay. And there is no prior inconsistent statement from Mr. Young. There is no inconsistent statement at all. There is nothing more than conflicting testimony. That is not what Rule 613 addressed. We are now way beyond the scope of the direct. If they want to raise this issue, they listed Mr. Young as a witness in their case in chief. If they want to raise it at that time, if they laid the factual predicate for that, they can either put Mr. Young on the stand first if they believe that's how they have to do it under Rule 613, or they can play Miss Meredith's testimony. That's how you lay that foundation. The cart is way before the horse here. It is risking serious prejudice to the jury. And then the court, well, generally this type of conflict is resolved truly through a stipulation by both parties. This comes many, many times where there's an issue of putting the cart before the horse. Are we going to elicit testimony in plaintiff's case in chief through cross or through defendant's case in chief through direct? There's 6 of one and half a dozen of the other. Most of the parties can agree to conflate it so we can call a witness one time and have it be done with. If the parties aren't willing to do that, it's fine, but it comes in. If you want it to come in now, it can come in now. If you want to wait and have defendants call Mr. Young back in their case in chief, we can do it that way too. This evidence comes in. And then Mr. Toth, they've said they're going to call him in their case in chief no matter what. I understand if it's Mr. Meredith's testimony, there may be specific facts that these specific distributors testify to. We understand the court has ruled that's it. That's in. What I'm very concerned about is this becoming unmoored into all sorts of other stuff. No distributor is going to testify to that. What concerned me is a great deal in Mr. Smith's opening, and I did not object out of professional respect to Mr. Smith. Mr. Smith said, distributors hear all kinds of things, and that makes them leave the company. Your Honor, we have been for 2 years. We have argued about disaggregation. The only thing that matters is what happened to these 13. It doesn't matter what other distributors heard. In the same way, we can't hear about all the other solicitations of people who didn't go to doTERRA. Having those wild statements about that none of these distributors heard, that is extremely prejudicial. I understand once they said it, he's going to have to testify about it. We understand that, but that doesn't mean, subject to the court's rulings, that's a much narrower subset of evidence, Your Honor. Oh my gosh, the court.
Whew.
I understand the concern about prejudice. However, it is also extremely relevant because of Young Living's damage theory. The point Young Living has made over and over and over is that it's entitled to millions of dollars in damages because, but for the violation of the non-solicit, all of these additional distributors would never have left. And so all of a sudden it becomes very relevant. What was out there? What was out there for people to hear? What might have caused the distributors to leave outside of the violation of the non-solicit? So it becomes very relevant, although also prejudicial. That's just the way the table's set. There's no way around it. Oh my God.
You okay?
Can you read Mr. Toth for
Yes. Yes, I was like, you
can tap in, cat.
Mr. Toth. But that testimony is then causational element to, let me just start that again.
Okay.
But that testimony is a causational element to that is it has come out from the mouths of the witnesses. Someone has to testify. I heard that, so I left. We understand that there are going to be witnesses that we've taken depositions of people who are going to say that. But that's a different subset of facts and a different subset of events that's than simply unmoored. Again, I use the word unmoored or untethered, bad acts, whatever statements people want to make. Frankly, in many cases, it would be completely false claims that people want to say, I left for X reason. If that comes in, it's a much narrower subset of evidence. They will have had to lay the foundation of that properly before Young Living has to deal with it at trial. That is why we have it that way, Your Honor. You know, that's the way we've set this up. You know, we originally tried to do them all in one. They wanted to do, no, we're going to have you to put your depositions on, and we're going to be able to bring these people because we control them. That's where we are.
Okay, the court, that's fine. If there's not a stipulation, there's not a stipulation. I only throw that out because it seems more efficient. If the parties don't want to stipulate to it, that's fine. We'll handle Mr. Young now, and defendants can call him back and do another direct later.
I'll do
And
Mr. Berger. One point that may be relevant to whether a stipulation is available, perhaps Your Honor could ask that. If we go into these issues with Mr. Young now, does that mean they won't need to call him in their case in chief? If that's the case, that would be relevant whether we enter into that stipulation.
The court is up. That's the point of it. That's the point of it, is to only have to call them once.
Mr. Berger?
Yep.
If we allow them to go into it now, will they stipulate that they will not call Mr. Young in their case in chief?
Okay, Mr. Gaylord, he's already testified about harm, the harm that is going to go to the company. This goes into the very issue you raised here. As to the stipulation, it's difficult for us. This is our first witness to say, yeah, we'll stipulate and let him not come back. It's just almost impossible. As you know, we don't know where this case might go and how it will progress. We do not want to be prohibited if testimony comes out that we can't recall Mr. Young if it becomes necessary. I mean, we can try to do as much as we can, and we don't know and won't know until the end. That's why the stipulation can't be formed, because we aren't sure how the evidence is going to come up until it comes in. We may need to call back witnesses. We may need to call back a bunch of witnesses depending on how this goes. And then the judge said, my concern is always, first and foremost, for the efficiency of these proceedings. I'm not here to strong-arm anybody into a stipulation. That's everyone else's business. If we're going to call Mr. Young back later, then I'll sustain the objection as far as the scope, and we'll handle it later. And
Thank
Mr.
you,
Toth,
Your Honor.
perfect.
And then Mr. Smith. I have to reserve to call him back, just like it was said by counsel.
Court said that's fine.
Back to Mr. Smith. And if the court wants me to handle it that way, I want the record to be clear that it is within the scope, because they open the door as to this loving family of distributors that never leave us. And once they get into that idea of these people, And once they get into the idea that these people, he got up here and talked about generally how they injure us for life and they never leave, the door got opened. If I have to come back, I can, but I've still got a lot more to go on similar subject. I'll make it as quick as I can.
Let's handle it all together when he comes back.
Altogether? How much altogether? I'll go if you think I am, or they do. I have other issues on the contracts themselves and the termination dates. And then you can tell me if I need to go somewhere else.
The court said, all right, with a specific objection that was made, I will sustain that as beyond the scope. And we'll just try to keep it more tailored to the contract itself. I recognize the damage issue that was alluded to, certainly indirect. If we're going to have Mr. Young come back and defend his case in chief, it's probably just as easy to resolve all of that at that time. And then Mr. Gaylord.
Despite the court's ruling, I want to make one more observation. We do have damages experts who are going to testify potentially about this massive damage they've suffered. And this testimony does go to that issue as it relates to that. And I think they've opened the door when they let him testify that I'm being harmed into ad infinitum. Do you know what that is?
Infinitum? No, I don't, but we could. Alexa. Oh, sorry.
They're being harmed into it.
Okay, she bailed me out. Live chat. I don't know. Can someone Google for us?
As a consequence, the door has been opened. My concern is when we get to Hoffman and Tados people, we're going to be fighting this battle because we want to ask him questions before they get to testify, because it deals with the harm and the harm he caused to the downlines and the decay rate of everything else.
All right, I'm going to put the judge back up. I understand the point. However, the jury has been instructed from the beginning that they have to wait and put the pieces together at the end. They can draw their conclusions about damages once they've heard both sides. That's no different from the posture of any case. Mr. Toth, thank you, Your Honor.
Mr. Smith, thank you, Your Honor.
All right, let's bring them back. Oh my gosh, the jury was gone for this whole time. Oh, dear God. Okay. Okay.
Court.
Yeah. Thank you. You may be seated. We're back on the record. The jury is present and we'll pick up where we left off with the cross-examination of Mr. Young, who remains under oath. Oh, sassy. Okay, go ahead, counsel.
Thank you. So Mr. Smith is talking. We're still looking at Exhibit 1021 in front of you. If I may approach, Your Honor, we got hard copies for the witness, and which may make it easier for him.
The court, I will advise counsel that the feedback I'm getting from my bailiff is that sometimes on the screen, if we don't have it popped out as it is now, they can't read it. So it's just a full page and no one can see it. Okay. Sorry. Mr. Gaylord.
Do you want me to do?
Yep.
Thank you, Your Honor. Oh, Mr. Smith. Mr. Young, on Exhibit 1021, when this was sent to Mr. Sterling, did you accuse him of creating an iron curtain between you and the employees of Young Living?
Yes.
What is an iron curtain?
If I may explain?
Yes.
My interpretation and this meaning was the employees have been threatened to talk to Mary and I. And so we have many employees that absolutely were in fear if they told us things that were going on within the company.
So now, at that time, you were living in Ecuador?
Yes.
And you were doing medical work down there, correct?
Yes.
You had patients?
Yes. And
you do surgeries?
Oh my God. I'm sorry, that he didn't say that. I worked in a surgical unit.
Can you imagine Gary Young saying, "Oh my God,
Mr. Gary Young is working in a surgical unit"? Are you serious?
We have to read this next part. You would actually perform. You had a video you display to your employees of you doing a surgery. Correct?
That's correct.
You're not a doctor?
Yes.
And you sent, if I can have you look at Exhibit 1160, I think it's in the same book. No, it's not. It's going to be in this book. 1160 is a multiple page email with that date up on the top of the first date is August 20th of 2007. Do you recognize that email from you?
Yes.
Move 1160 into evidence, Your Honor.
Any objection? And then Mr. Toss said stipulated. Judge said received. And then Mr. Smith.
This email, sir, was sent by you in response to an email that was sent to you by David Sterling, correct?
Without reading it, I can't recall exactly.
If you go, maybe this will help. If you go to page 2 of that document, down at the bottom, there's another email from David Sterling to you, and it's dated earlier in time. So you go to page 2, down at the bottom right, starting at 1702 or 1702 p.m. on August 17th, there's an email from David Sterling to you. Do you see that?
Yes.
And then your response back on page 1 at the top was dated August 20th, 2007. Does that refresh your memory? You responded 3 days later?
Yes.
And just to make it clear, this email says Sundance. That's an email account that you and your wife use together, you and Mary.
Yes.
And in that regard, Mr. Sterling wrote you on the 17th, back to the bottom of the email on page 2, the very last paragraph. It says, quote, when I left Wednesday night, end quote, I want you to assume for a moment that's Wednesday night, August 8th. So back to this quote, I did so with the understanding I was being terminated, end quote. Do you recall Mr. Sterling telling you in mid-month that he had been terminated on August 8th? Do you remember writing this and saying that?
Yeah, he said understanding.
Okay. His understanding was, and he told people at the company he had been terminated, right?
I don't know.
You don't remember that?
No.
And then it said in this next sentence, it says, quote, when I heard that Gary, end quote, meaning you, quote, had said in the employee meeting the next day about me being on a 3-week sabbatical and working from home, I went through an emotional roller coaster believing I would be back, end quote. Did you see that?
Yes.
Is it true that after that meeting that you had on August 8th, that you told the employees that Mr. Sterling was on a 3-week sabbatical?
I don't remember the exact time, but that was the conversation from the very beginning was he was on a sabbatical or administrative leave pending the investigation.
Now, let's just make sure I understand. During this investigation sabbatical, he was not allowed to return to the office, right?
Right.
He was relieved of all duties?
Incorrect.
What duties was he not relieved of?
I gave him the opportunity to work from home during this time of investigation.
To be his own boss.
Yeah.
Work from home, but not contact a single employee. Want to go back to your list? Remember that?
That's okay.
Work from home, but not contact any employees, right?
Correct.
How does a COO work from home and not contact a single employee?
Has a separation for a sabbatical for administrative leave relieves one of those duties of a chief operating officer.
So his duties were done. He was relieved.
I gave him an opportunity of special assignments pending the investigation.
And there were no special assignments. And the only thing you said is don't talk to any employees, right? No assignments?
There were.
No assignments?
Yes, there were.
You gave him an assignment? What assignment did you give him?
Not in this letter.
In any letter? You gave him an assignment in some letter? Would you be able to show us?
We had a conversation.
So it's not a letter, just to make it clear?
I don't remember whether it was specifically addressed in a letter or not.
Now you're saying it's a conversation you had, right? Before the date of exhibit number 1160. Is that the case?
Yes.
In 1160, he says you hadn't been able to speak to him. He says he hadn't been able to speak to you since he was fired. Up on the first paragraph on page 2 of his email to you, it says, quote, I am disappointed, end quote. Down below, first paragraph under David Sterling. One more down, no right there. Quote, I was disappointed to not be able to connect with you before I left again to Ecuador, end quote. Is that true that you did not speak with him between August 8th and the date this email was written by on August 17th?
That was probably correct.
You didn't speak to him when you wrote your email on August 20th. You said, quote, I haven't spoken to you. I was busy, end quote.
Correct.
I was busy treating my patients in Ecuador?
Incorrect.
You didn't say that?
Didn't say that.
Can you look on your...
I made attempt to contact Mr. Sterling and it shows in that letter.
And on the first page, 3 paragraphs from the bottom, I apologize. If you blow that one up, quote, I apologize. I apologize for the delay in communication, but since I returned, I've been overwhelmed with new patients, end quote. You were in Ecuador treating new patients and couldn't talk to Mr. Sterling, correct? Right?
The communication from Ecuador to the U.S. is very difficult for those that have been there and tried calling back. That is correct.
And so there had been no assignments made to him under what you call the sabbatical from at least from the date you had the meeting with him on August 8th that you won't say is a termination up until the date of your email date of August 20th. 12 days, right?
When I walked Mr. Sterling down to his office.
Objection. Non-responsiveness to question posed.
Okay. Judge, why don't you rephrase the question so you can redirect him?
Back to Mr. Smith. There had been no communications with him between the date he was terminated. I use a date, August 8th. You don't like the word termination. August 8th, and the date of your email dated August 20th?
Yes, because I called his home several times and I spoke with his wife, but he was never available.
So you had no communications with him?
With Dave, no. He never returned my calls.
And you made no assignments to him, as you claim?
He couldn't. He never returned my calls.
In this letter you sent, up on the fourth paragraph down from of the first page, I asked you if you had religious undertone in your company. You said in the fourth paragraph down, quote, "These things are repairable through repentance and forgiveness on both parts," end quote. Is that religious overtone in your mind?
Where are we at?
Fourth paragraph. Quote, "These things are repairable through repentance and forgiveness," end quote. Do you see that?
Yes.
Did you later on describe Emily Wright as having been overcome by Satan in his email? In an email?
I don't remember that. Surprise, surprise.
You don't remember that either. Did you say Greg Newell, I think an ambassador, was Satan's spawn? Did you call him that?
I could have. I don't remember.
In the same paragraph, you say, quote, "The reason you got rid of him was because it was evident to my distributors my name was not mentioned and my pictures was kept out of the magazine," end quote. Did you see that? Same paragraph, just 4 lines down. You're talking about the company magazine, correct?
Okay, yes.
And you were upset that your picture was not in the company magazine.
Right.
You didn't like the change of focus from you, who really was the guy who kind of brought essential oils to the forefront, to not being the guy that was at the forefront, correct?
Correct.
You thought it was bad for the company?
Correct.
And you told him that you were upset that he had dug his feet in what you said, quote, "You dug your feet into doing something about Quackwatch," end quote. Did you see that?
Correct.
Quackwatch is some website out there that has all kinds of negative stuff about you.
And others, yes.
And you've read that?
Yes.
And turn your book and see if you recognize the Quackwatch article. It's exhibit 1079. Make sure I've got the book right for you.
Mr. Toth, Your Honor. Judge says yes. Mr. Toth said, "Your Honor, we object to the use of this exhibit. Do you want to talk about it on the sidebar? We can do that, or I can make it from here."
Mr. Smith, I don't plan on displaying it to the jury.
If there's no motion to receive it, we'll just hold on to that. And then Mr. Toth, "Thank you, Your Honor." Mr. Smith.
Do you recognize this article?
Yes.
I'd move it into evidence, Your Honor. I won't display it at this time.
All right. There is a motion for me to receive it, but you want to be heard on it, correct? And then Mr. Toth says, yes, we would object to its admissibility as evidence. First of all, it's hearsay. Judge, come on up. Sidebar discussion. We're back to Mr. Smith.
And this was the Quackwatch article that you were referring to in your letter to Mr. Sterling?
Likely so.
Move it into evidence.
Mr. Toth, same objections. Oh, I forgot to highlight the court. It doesn't matter. Okay. And then the court said, let's have him look it over. I think we've just got a paragraph that.
I gave him the whole exhibit in front of him, Your Honor. He has a whole exhibit.
Well, look at the exhibit, Mr. Young, and see if it appears to be. Look at the exhibit. He's asking you if that's the Quackwatch art. Okay, sorry, Quackwatch article. So I'd like you to look at it and see if that is consistent with your memory. The witness, Gary Young, you know, Your Honor, I can't honestly say this was the reason for what I wrote in the letter because there was a lot of conversations. There was a lot of issues on the internet. This one here, I can't say specifically. Oh, no kidding. No kidding, Gary. Got it. Okay.
Let me see if I understand. When you wrote the letter to Mr. Sterling, which if we can go back to exhibit number 1160, that's in evidence, you mentioned he dug his heels in about Quackwatch. Do you remember that statement?
Yes.
There is only one article on Quackwatch about you, right?
Oh, I don't know that.
Yes, you do. Well, when you saw the one, you saw one on Quackwatch, just one. Is that what you're saying?
I didn't watch it. My attorneys talked to me about it. We talked about it. I didn't specifically go into the internet. What do you mean go into the internet? Go onto the internet? You log in? Like, what the hell? Like, you've never been on the
He
internet
didn't
before?
watch it.
Oh my God. I didn't specifically go into the internet and look and see, so I didn't read in detail.
There were a lot of complaints by people about the Quackwatch fair.
That I don't know.
Yes, you do.
Oh,
You
Gary-
wanted it off because
Yeah.
it was affecting your company, fair.
yes.
And you wanted to fire Mr. Sterling because you felt he dug his feet in about doing something about Quackwatch, fair?
I felt he was using this against me.
Meaning that because there were so many negative things said about you on Quackwatch, it benefited him to control of the company. Is that correct?
Sorry, I was distracted. I don't understand. Oh, no kidding. I don't understand your question.
How was he using it against you, I guess is the question. You said you thought he was using it against you. That was because of all the negative comments within Quackwatch, correct?
Yes. Oh, sorry. I was in the wrong spot. There was only a few that were having a problem with it.
Now I'm in the wrong spot. Okay. But there was some, apparently.
There were some. I was told I never had one ever come to me about it.
Then why would you fire your COO if you never had a single distributor come to you about Quackwatch?
This
Or Quackwatch, or the Quackwatch issue?
Mr. Toth, objection, mischaracterizes testimony. Then
This-
Gary, this was
Great.
not the reason. Then Mr. Smith.
When you said this was not the reason you fired him?
Why? The judge did not. Maybe he. Okay, I thought the judge had to rule on objections, but okay, I'm not a lawyer. This was not the sole reason.
Not the sole reason, but part of the reason, fair?
Right.
Okay. And you since paid someone to take Quackwatch down, right? You had your lawyers effectively take the Quackwatch down?
The entire site?
The article.
Mom- Oh wait, Mombi, is Quackwatch still up? Okay, she's gonna share
Both
stuff.
had been removed, but she found it because she's awesome like that.
Sweet. Okay. Sorry. Where were we? I'm lost. Okay, Mr. Toth. Wait.
It was taken
it was
down.
taken down,
19.
When was it taken down?
When was it taken? Yeah.
Oh, that's you. Sorry. I'm so upset over Gary Young and also Quackwatch. I'm just like, oh, my brain is literally
Yeah.
breaking on live right now. I'm
Same.
going to say within the last 5 years, I don't remember exactly.
So if we're 2017, it's since 2012 been taken down?
Perhaps. Oh my God.
Who
Answer the question, buddy.
who did you employ to take down the Quackwatch article?
Sean Stewart was the chief legal counsel at the time.
And that is, of course, because the company did not want to have the negative information out about you that may affect someone's interest in buying the product. Fair?
That's possible.
That's why this is part of the reason why distributors will never say what company they're part of most of the time, because they don't want people to Google about the company.
They don't want people going into the internet and finding bad stuff about the company. Oh my God.
In exhibit 1160, still we have on the board that on that same page down near the bottom in the paragraph that starts with, quote, "I apologize," end quote. No, excuse me. It starts with, "I'm sending a separation agreement." Did you ever send a separation agreement to Mr. Sterling?
I believe there was.
You said in the same paragraph that it says, quote, "You have said to distributors that the magic is gone from Young Living, but they say you haven't figured that out figured out that Gary Young is the magic of Young Living, end quote.
Are you sorry?
Yeah. Well, let me read it again.
Okay.
So you said in that same paragraph, it says, you have said to distributors that the magic is gone from Young Living, but they say you haven't figured out that Gary Young is the magic of Young Living.
Ugh.
Did you consider yourself the magic of Young Living at that time?
No, I was the founder of Young Living.
You were the founder and the creator?
Yes.
And you don't recall ever telling David Sterling that perhaps he too was possessed by Satan?
No, I don't recall.
Let's turn to the next page in this same letter. And let's go to the second paragraph where it says, quote, I see, end quote. On page 2, it says, I see the good in you and your wife, but Dave, you lost the vision and Satan exercised dominion over you. Domination. He's saying to Dave that he lost his vision and Satan exercised dominion over him. Does that refresh your memory that you even said Mr. Sterling is somehow possessed by Satan?
I just got shocked. Apologies. Yes, I see that.
Do you want to change your testimony about you have had do you want to change your testimony about you have had religious overtone in your company, or you still don't think that's the case?
In the spirit of Amber Heard, no, there's a difference between religious overtone and spirituality. What? Sir, Gary Young just said, no, there's a difference between religious overtone and spirituality. Are you kidding me? Are you kidding me?
And how would this not be religious overtone?
Yeah. And it's just like he's mincing words, and he's just like not fruit salad, word salad. Oh my God. He's just like, oh no, it's different. It's different.
It's different. No.
Yes, I pledge. Literally, Dave. Where's my mouse? It's messed up. Okay. All right.
So I guess he's saying that it's spirituality.
So yeah, so he characterizes it as a different word. So he's not going to claim that there's religious overtones. He's saying he's spiritual. So he's
spirituality overtone.
Yeah, and he's saying that he probably did say he was possessed by Satan, but he's not going to say that's a religious overtone. He's saying that he actually believes it, but he's not going to like admit to anything because the guy's not saying it correctly.
Mm-hmm.
Oh my gosh.
How about the next sentence where it says, quote, Satan has exercised dominion over you to the point where you started thinking that you had knowledge and ability greater than anyone, including me, the creator of the company, end quote. Do you see any religious tones in that statement?
No.
Do you think that was correct, that you had more knowledge and more knowledge and greater ability than anyone else? Is that how you viewed yourself?
Objection to form, mischaracterizes the document. Judge says, I'll have you rephrase. And then Mr. Smith.
Sure. When you say, quote, Dave, you think you had the knowledge and ability greater than anyone, including me, end quote, you're saying that you think you had greater knowledge and ability than David Sterling, right?
Correct.
You called your office in Leahy and at the time church headquarters.
Say that again.
Yeah. You called your office in Leahy church headquarters.
That's absolutely false.
Let's go to the first page on the paragraph right here that says, quote, all the gossip roads, end quote. One of the problems here was you had a lot of gossip about your company and still do, right?
I don't know.
Well, like Quackwatch, the gossip generated by Quackwatch would be a good example.
Fair.
Whether true or not, there was gossip out there all the time about you, right? Remember that gossip?
Okay, I see what you're saying, yes.
Well, now my question to you is, you just said your office building, my question to you is, you just said your office building is church headquarters in that sentence. Do you see that?
It was figuratively speaking.
Okay, I'm asking you, you called your office church headquarters?
No, I didn't call it.
When you call it, quote, church headquarters, end quote, that's out of your mouth?
Right.
Your fingers?
This was my letter.
Did you call Greg Anderson one of the people on the list? I can't show the board. Did you call him one of the 12 disciples?
No.
You didn't know Boyd Truman, correct?
Yes.
Oh, you did?
Yes.
How did you know him?
Him and his wife were personal friends of my wife's. Their whole family was personal friends. We had them in our home. We'd been in their home in St. George. They attended meetings.
They traveled with you to Europe, remember? They went to Turkey with you?
Yes.
And they don't like you, right?
I don't know.
Did they ever tell you how they don't like you?
No, they never did.
At the time, this contract with Mr. Sterling that we've been talking about in your termination of him, at the time, that policy and procedures memo that for the distributors, I think it's called the policies and procedures. Would you like me to point that out to you so you can look at it? Look at it.
Sure.
It's marked as 1136. I'm going to hand these. Take that one. You won't be able to stand long enough to get you won't be on the stand long enough to get to the practice. Oh my gosh. Do you recognize exhibit 1136?
Okay.
They're the policies and procedures of Young Living. Is that correct? Is that accurate?
Yes, I'm assuming this is correct.
And they have the date on them, December 2003. Is that fair?
Yes.
I'd move 1136 into evidence.
Any objection? Mr. Toth, no objection, Your Honor. The judge said 1136 is received, and we're back to Mr. Smith.
At that time, that one of the distributors would leave. Let's say, you said they always leave. That's your comment earlier. When they leave, their position rolls up, correct?
Yes.
And that's automatic?
Pardon?
That's automatic?
Yes.
That and explain that to the jury. If I call it the pyramid or the tree. If I was somewhere in the tree and I was one of your distributors and I left, my entire downline would move up one position. Is that fair?
Yes.
And so the person who was above me would then be responsible for training and managing and get the commissions from that downline.
Okay, I'm going to say yes, but I'm taking a pause. The way that the pyramid works, I don't want to go too far into it, but you're getting paid 6 levels down in Young Living at any time. So it's not just that you're only getting paid by the person you directly signed up under or that you were stacked into. Young Living pays 6 levels down. So when they're talking about here getting sucked up to the next one if someone leaves, that just means that another level above them is activated. So if they were only paying this many, whatever. If they're paying the original 6 levels up, one person leaves, that means the person, it's the whole thing. You're getting paid multiple levels down at any one time. So the oil that you buy has to pay 6 people. It has to pay you or the person above you and then 5 people above them. So that's where the markup comes in. So when they're talking about training and managing or whatever, and then they get commission, that's true, but that doesn't paint a complete picture if you've never been in a multi-level marketing company or if you've never been in Young Living. So not that that's super important, but
no, it helps. It's important.
All right. I'm sorry, I didn't mean to derail us, but I
you're
did
good.
it naturally. Okay. So then I said not line 10, yes, and then did you already read 11 and
okay. 11?
Yeah, I think line 11. I think we talked about the roll up, right, on line 9, and then I said maybe yes.
Yes.
Okay.
Okay.
So I think we're on line 11, yeah.
Yeah. Okay. And it was also part of the policies of the company that one of your distributors could do anything they wanted to when they joined. And you've described that they could either become a good distributor or they could sit back and only buy the product for themselves, correct?
Correct.
And some were good and some were not good.
Wouldn't say they were good or not good.
How would you describe it? How would you put it into terms of making money or not? That may not.
Some wanted to build a business and some didn't want to.
Fair enough. The ones who didn't want to build a business would buy for their own purpose,
Yes.
and they wouldn't qualify for commissions.
Some of them, yes.
At the time in 2004, Young Living lost more distributors than it enrolled, correct?
That I don't know.
The company kept records of distributor add-ons and distributor losses. Is that correct?
They do.
I want to show you Exhibit 1134. It may be in the same book you have. It is 1134 is a 1134 is a one-page document that was produced by Young Living with the bait stamp of 16569 on the bottom. Do you recognize this document?
I don't recognize this particular document, no.
Is this the kind of document that would have been maintained by Young Living for the purpose of showing its enrollments and those who dropped?
Let me just highlight these real quick.
We need
Sorry.
that. They need to publish that publicly every year.
Okay, sorry. I thought I got all these. So you just finished 919, right?
Yes.
Okay.
Yeah. Mm-hmm.
Okay.
Talking about the document that would have been maintained, the showing its enrollments and those who dropped.
Okay. Your Honor, I'm going to object. I'll object to form here. I don't think we've established any foundation. The witness has just said he doesn't recognize the document. And then Mr. Smith.
I'm laying the foundation.
I understood it to be foundational questions, so we'll see how far we get.
Back to Mr. Smith. Did you understand my question? Yes, there would have been a document similar to this, and who usually I just answered. Did you understand my question, Mr.
Yes.
Gary Young?
Yes, there would have been a document similar to this.
And who usually maintains that? Somebody at the company?
Yes.
If the company produced this in discovery, would you think that it's likely generated by the company?
Say that again, please. God dang it, Gary.
If the company produced this in discovery in this case, would you think that would have been prepared by the company in the ordinary course of its business?
Mr. Toth, object to foundation. Court says overruled. Gary Young says, I would think so. Mr. Smith.
I'd move 1134 into evidence, Your Honor.
Mr. Toth said, Your Honor. Oops, Mr. Toth. Your Honor, again, I'm going to object to foundation. He hasn't established the witness knows anything about this document. He's managed to get the witness to say this company generates reports that sometimes tracks these things. There's no foundation whatsoever that this witness has any familiarity with the document or the information that's contained within it. And then Mr. Smith.
It's also an admission by the party, produced by the party in this case. Produced by the party in this case, 1134.
That doesn't make this witness the appropriate witness to bring that in with or to discuss with this, Your Honor.
There's no better witness than the man who owns at least half the company. It's an admission of Young Living because it was produced and it is a admission by them. That's sufficient foundation in and itself. He indicates it's generally prepared in the nature of business.
Sorry. Nature of business.
Fair
I'm
enough.
sorry. What?
Oh, 15.
What line are we on? Line 15. Okay, sorry.
It's
sorry. There's like the lines are running together.
They are.
Your Honor, it was a document produced in litigation. It's also been superseded by a subsequent production by Young Living. And this witness hasn't ever seen this document. He just testified he's not familiar with it. Judge says, I'm sustaining the objection. Mr. Smith.
Your Honor, 1136. They didn't object to it. There are no objections at all pre-trial.
Judge said 1136, I have received it, but.
1134, I apologize.
And then Mr. Toth, yes, we did.
No objection on foundation.
Mr. Toth, its foundation depends on it would depend on what witness you're talking to about it if you're objecting to foundation. If he's got a witness on the stand, you can't establish foundation. Second, it's irrelevant. Wait, you should have just said B. He said A first. Okay, whatever. Second, it's irrelevant. This was produced by Young Living, but this document has been superseded by other information produced by Young Living in this case. The foundational objection isn't something you would know that until the lawyer was trying to use it in trial, Your Honor.
Your Honor, pretrial rules require an identification for foundation objections. In the pretrial report, there was no objection to the foundation.
Mr. Toth, that's not accurate, Your Honor. You can't know whether there's going to be foundation. There may be a witness. He may be able to locate a witness who has foundation to discuss this. This isn't the witness. He just testified he doesn't have any foundation to discuss it. That doesn't change that objection, and we don't waive that objection by not knowing every single witness he may try to introduce our documents through. Judge said the objection is sustained. Oh my God, Mr. Smith. Okay.
How many distributors were there in 2003 when David Sterling was hired?
Based on this report?
Not based on the report, based on your memory.
I'm not going to try and put a number on that. I don't know.
Can you give us a range?
No.
Were there about 70,000 to 100,000, or you don't know?
I'm not going to say. I don't accurately know.
When you terminated David Sterling's employment, would you agree that there were 120,000 active distributors?
Mr. Toth, objection asked and answered. Gary Young said it's possible. Judge said overruled. And then Gary Young said, I don't know the numbers. And we're back to Mr. Smith.
This report, does it refresh your memory in any way?
The one that's on exhibit.
Yes, 1134.
Which column are you referring to?
Any of them. Any that might refresh your memory.
Yeah, it's very possible that these numbers could be correct. I'm not familiar with the numbers.
When this case was tried, there was a witness called a 30B6 witness. That's a person Young Living designates as the person most knowledgeable, and a man named Mr. Pace showed up. Did you order Mr. Pace to show up for that depot?
Mr. who?
Pace, Pace.
Mr. Toth, objection, foundation, Your Honor. Gary Young, I'm not recalling that name. Court said overruled. Go ahead.
You don't recall a Mr. Pace working for Young Living?
Pace?
Pace.
Oh, Kevin Pace. He was the CFO. Oh my God. You forgot the name of your CFO. Are you freaking...
I was thinking maybe it was just like a kind of a small position, maybe.
Yeah, you're like, like the mail guy or the janitor or, like somebody who might have higher turnover than your CFO. Oh my God. Oh my God.
Now at least we have the right guy. Do you remember telling him to show up to...
Whoops, sorry. Turn off my highlighter. Okay.
Show up to a deposition in this case?
I don't remember telling him to show up there. That wasn't my position.
He reported to you?
Yes.
And he reported in the deposition on behalf of Young Living as a person most knowledgeable for your company on this case. Do you understand that?
On the numbers, yes. And then Mr. Toth, objection, Your Honor. There's no person most knowledgeable rule in Utah. That doesn't exist. It's a California rule where Mr. Smith practices. And he called as a 30B6 witness, which is a decision that's handled by counsel. This witness completely lacks foundation to try to talk about whether he was ordered to show up as a person with knowledge. And Mr. Smith?
I object to that speaking objection. And I think it was very inappropriate, quite frankly.
The court is the objection, foundation, or help me. Mr. Toth, it's the form of the question is improper. There is no person with knowledge. He's actually starting to border on questions that invade the attorney-client privilege about who was selected to show up for a deposition. And he's asking a witness he's never laid any foundation for to be able to answer that question. The question would be, has Mr. Young been involved in ordering witnesses to depositions? And if the answer is no, then it doesn't matter what Kevin, to suggest that Mr. Young out of the blue says, did you order him to show up for a deposition, is completely confusing the witness. And then the court said, why don't we rephrase the question?
And Mr. Smith says, the question is, did you have any part in directing Kevin Pace to appear for a deposition in this case?
No.
To provide testimony on behalf of Young Living?
No.
As a CFO, the person, CEO, the person in charge, are you saying you did not know that Kevin Pace was showing up on behalf of the company to provide testimony on behalf of your company?
Yes, I knew he was showing up.
So you knew in advance he was coming down to provide testimony?
Yes.
And you knew he was providing testimony on the subject matters listed within the designation. Is that correct?
Yes.
And you expected his testimony to be accurate?
Yes.
When he gave testimony on the financial statements provided to us, you thought that was accurate, right?
Yes, if he provided it.
Well, this down here below on the bottom of what's been marked as 1135, 1134, has what's called a Young Living designator and attorney's eyes only. Have you seen attorney's eyes only documents from Young Living before? I use the term YL. Is that okay? I use that term for Young Living. I don't know if that's a term you use back at headquarters.
That's okay.
Have you seen those kind of documents that are marked attorney's eyes only YL?
You mean the actual YL and the code?
Yes.
I've seen different codes on different documents.
You know, at the time that Mr. Sterling's contract was signed with the company in 2004, that the Young Living distributor upline support team was expected to have relationships with all the distributors' downlines, correct?
Can you rephrase that?
Sure. In this tree where there's distributors above, up above, and down below, you expected an upline distributor to have relationships with the downline distributor, correct?
It was automatic.
Automatic. So if one left, the upline was able to step in and help provide the support necessary, correct?
Not always.
But that was what was expected.
Yes.
And with regard to, we talked about this briefly, but with regard to distributors, when they came over to Young Living, if they wanted to do nothing, they could. They could just, like you say, sit back and just buy the product, correct?
Correct.
Is there a term called squatter? Have you heard that before?
No.
What do you call when someone really does nothing but buys enough personal volume to qualify for commissions but provides no support or anything like that?
What do I call them?
Yeah,
A non-builder.
non-builder. So it was okay to have non-builders in the company.
Of course.
If they're not building, then why just not be a customer? All right. Yeah. And Gina Truman and Boyd Truman were non-builders?
They were building.
They were builders?
They were beginning, yes.
Beginning?
Yeah.
Would you agree that Boyd Truman's downline had decreased every year since 2005?
That I didn't know.
Okay. So when you say they're building, you don't know if they're building either. Same way you don't know if they weren't building, fair?
Every time we did meetings, they were always present. They came to every convention.
So you have no idea when you say they came to every convention. Are you saying that Gina Truman came to every convention?
Well, no, I can't say that because they weren't in the beginning.
Okay, so they weren't going to every convention, correct?
Correct.
But you don't know if they were building or not building, fair?
I assumed they were building.
Assumed, but you don't know.
Because I personally went to St. George and did meetings for them.
But the best way to tell if they were having any success is to see if they were organizational volume was going up or down, correct?
Correct.
And if it's going down, they weren't building, correct?
Correct.
And your company records would reflect if they were going down, correct?
That could be possible. I don't have
But you know that Gina Truman filed a bankruptcy in 2008, just after the first of the year.
I heard of that.
That was because she didn't make enough money in her Young Living downline. Is that correct?
Mr. Toth, objection to form foundation. Judge says overruled. Gary Young says Gina also was going through a divorce, and we're back to Mr. Smith.
Okay, the combination was bad.
I assume.
And how about Boyd Truman? He was going through a divorce?
No.
Only his wife was going through a divorce. He filed a bankruptcy too, right?
I don't recall Boyd Truman filing bankruptcy.
Now, after that email that we showed a moment ago, dated November 20th of 2007, you never had any more communications with David Sterling, correct?
No.
Was that the end of it?
I believe so.
And you still think he got fired September 7th, right?
Never
spoke to him again from August 20th, but he got fired on September 7th. Is that your testimony?
It's possible.
Who fired him now?
I was responsible for
You?
his absence and his termination later.
Meaning you terminated him on August 8th and he never showed up for work again?
Mr. Toth says objection, form, witness. Gary Young says right, court says overruled, and Mr. Smith.
I have no other questions at this time, Your Honor. I would reserve my other questions when the witness comes back on my case in chief.
Okay, I think we're at the end, and I know Kat has to go.
Well, my husband's gonna bring in my little. I mean, he can
okay.
be in here.
Okay,
yeah,
that's fine. Oh yeah, that's fine. Okay. So the court says,
sorry.
All right, I think. And then Mr. Gaylord says, I'm looking at the clock, wondering if I can finish in 15 minutes. What's the court's preference? The court says, how long do you need? Mr. Gaylord, would you prefer to recess and resume in the morning? Mr. Gaylord, I can probably cut a dramatic amount based on what Mr. Smith has done. If we took a recess and came back in the morning, that would be my guess. Court says, all right. And then Mr. Gaylord says, I have enough. I'm thinking I could. It might take me 45 minutes if I don't cut. I may be able to cut it down to 15, but if I have time. The court said... This
is an important comment about the Truman.
The Trumans are the tippy top of doTERRA? Wow.
After bankruptcy?
Dang. Wow.
And created a Symphony of the Cells. Symphony of the Cells. Is that a book?
What is all this? This is like, I'm very curious. Jamie, we need the tea.
Yep.
Holy cow.
Is that, what is this one? Oh, this is The Essential Life.
Oh wow. Is that a doTERRA book or a?
Mm-hmm. Yeah, I'm doing a review over it.
Oh, cool.
Super big.
That's awesome. We'll take a recess and reconvene in the morning. In the interim, I will remind you of my standing order not to discuss the case with anyone or with one another. I'll also advise you that scheduling going forward, I think the note on the door tells you, but just to make sure that you know the schedule going forward on Thursdays, we're not in session for this matter. I have to have a day to do everything else that needs hearing. So Thursday, I'm doing other hearings and we won't have you come in. You will return tomorrow and also on Friday. I will have you meet with Casey downstairs, meet with her at 8:30, and she'll bring you up from there, and we'll get going. All right? We'll excuse you for the evening. Court's excused. And the court said, thank you. You may be seated. Any matters before I excuse everyone? Mr. Toth, we're over you, okay? Can Mr. Young be excused from the stand? The court says, yes, of course. Gary, thank you, Your Honor. Mr. Gaylord. I think there's just two open issues that we're going to remind the court of designations of depositions and whether the court had an opportunity to at least make copies or make those available. I haven't made any copies of those. We can certainly do that. I've got defendants, joint objections to plaintiffs, counter designations, and plaintiffs' objections to defendants' designations. We can make copies of those and get those to you. Do you want to take over, Mr. Gaylord? Or
Yeah.
Okay.
Then we had talk amongst counsel. I don't know what the court's desire is in terms of jurors. In cases we've done in the past, we've kind of split costs of helping them cover their lunches. I don't know if they want that. We're happy to bring in lunch if they want to hang out for a 9-hour day, or if they want to get out, that's fine. We talked amongst counsel. We're happy to offer that to our court if that's something the court would be interested in. I want free lunch.
Yeah, Mr. Berger, we are, Your Honor, if that suits the court. The court said I've never had that come up. Usually we've just had them be on their own until they're in deliberations. If that's something you want to extend to them, then I'm certainly happy to approach. We can have Casey ask them if they want to have something brought in. Of course they do. They're getting $15 a day. Are you kidding? Okay, sorry.
I mean, I might pay to watch this, so
Yeah.
if that's what they'd like.
Or they can presume to escape for a while. I can have Casey ask and see what they like. Then Mr. Toth, thanks, Your Honor. Thanks, Your Honor.
Thanks.
Anything else then? Mr. Smith, where are you? No, Your Honor, thank you. I'll give these. Would you make some copies of these? And then the bailiff said, yeah.
How many copies?
Mr.
3 is
Berger.
fine. One for each set of counsel.
Yeah, go ahead, sorry.
3 is fine. One for each set of counsel, please.
Okay. Court. All right. We'll make those copies. Thank you. We'll be in recess. Thank you, Your Honor. Okay, Mr. Gaylord. Thank you. And then Mr. Smith. Okay. Why are there reporter certificate? Sidebars. Do you want to read the sidebars?
Oh, the sidebars.
Or do we need to end this and we can read this for the next
It's only 2 pages.
Yeah. Do you want to just read it?
Yeah.
Okay.
Mr. Smith, he has about 40 minutes. Can we take a break and we'll come back and I'll finish my argument after lunch?
Okay, perfect. Sounds good. So that one wasn't super interesting. And then we're at Mr. Toth. We're back into the Aromatic Research Management Company agreements, and that's what they're trying to show him again. We haven't opened that door to that. We haven't talked about those arguments. This is way beyond the direct, and this particular line of questioning has already been dealt with, Your Honor.
Mr. Smith, this is Sterling's employment agreement. Am I going to get sued on this agreement, my client? This is it.
Isn't this the Young Living agreement? Mr. Toth, I thought this was the Aromatic Research.
I don't think you're looking at it.
Court doesn't say it at the top, so I can't. What agreement am I seeing?
Mr. Gaylord said, well, Mr. Smith said, this is what they're suing my client.
Now it's down.
Mr. Smith, it's flipping off. You must know that already.
Sorry, we just lost the agreement. Oh my God.
What exhibit number is it? I think it's exhibit 9. That's what I'm told.
Okay. Hawkins. Oh no, I mishighlighted Hawkins. He's supposed to be purple. I'll fix it. Plaintiffs 9, and then Mr. Toth. Mr. Smith, I apologize. Withdraw that objection. Okay. That's it.
Whew. That was pretty good timing.
Yeah. We cut it close. Live chat. So we probably need to see if someone wants to volunteer to work the back end of the live chat to be able to have it pop up on the screen if possible for the next live that we do. If someone would be available. Hi, Champion.
That'd be awesome.
Maybe I'll ask in the Discord if someone's available to do that. You don't need to make a copy for Miss Mombi. She'll grab her own. Yes. Kira's the best.
Oh,
sorry.
No, you're good.
My cats have the zoomies. Yeah, my dog is. Cat, are you in our Discord?
No, I'm not.
Okay, I'll add you, or I'll send you the link for it. It's
okay,
just,
yeah, that'd be great.
Keep it private, and it's just like people from the live chat who are in there.
Okay.
Yeah. We share links and stuff.
The tea.
Yeah,
That'd
literally
be
the
awesome.
tea is wild. Oh my god.
Yeah, the only Discord, I'm in a couple of them, like for Your Morning Guru and Savvy's, but I don't get on super often. But yeah.
Yeah, we just post like unlisted links there, and then Mombi's posting, Kira's been posting Young Living stuff in there. So
Oh, good.
yeah.
So there was some interesting nuggets here and there. Him doing surgery, the oil to cure homosexuality. I think that was the verbiage that they used.
Yeah, and him not having religious overtones, he calls it spirituality or whatever, and it's like, come on, it's some kind of overtone. I mean, you're either going to call it religious overtones or you're calling it has to be spirituality. I mean, pick one. It's something. It's
The
not
people being basically controlled by Satan.
Yeah.
And yeah.
You can't just say in a workplace, "Oh, I think you're possessed by Satan." Give me a break. I mean, and again, I wouldn't want to work in this place where my boss was accusing me of being possessed by Satan. Are you
right? Serious? That's a huge red flag.
Dave, oh my gosh.
That would, yeah, huge red flag. Time to go.
Yeah.
For many reasons.
There's more. Gary Young is going to be tested. There's in the next transcript, the second defendant group is going to ask Gary some questions. I think some more crap is going to come out. But I feel like they're trying to get stuff in, and the stuff is coming out. It came out in this cross-examination, and it doesn't look good for me. I mean, he said himself that he was on a surgical unit or surgical team or whatever. Oh my god. Jamie, glad you're here. It's been a wild ride so far. These are all in a playlist. There was one video where Kat wasn't able to join me, and I just read like the boring kind of opening statements, but there was some interesting parts. So that's in my playlist, but I need to send that over to her so she can upload it to her channel too. Maybe the Seed to Seal Demon Seed to 7.
Oh, that was another thing. The seed to seal. Yeah,
they quit. They quit because it's coming out that they didn't have enough farms to supply the oils to meet the demand for the number of brand partners they had, which that's a good question.
So scammy.
Yep.
I mean, it's not surprising at all, but the actual proof of that is something that a lot of distributors, I don't even know if they know.
Yeah, they don't. I don't think they do. And if they do, then they're not. I mean, some of the big leaders, I mean, I've been messaging someone and they were saying that they didn't see how the farms could have managed the number of the bottles that they were actually producing. So it's been wild.
And not with the increase, or I mean, they have had a lot of decrease, but from when it was increasing, they wouldn't have had enough farms.
Yeah, and they didn't even have enough farms, I don't think, in 2007 or when, because they were saying that in 2007 they didn't have the ability to claim Seed to Seal because they didn't have the number of farms to manage the number of people. So and again, when we ask questions, we're just haters or whatever, and it's like, I mean, he's saying it here. He's saying that they did not increase the number of farms 10 to 12 times to match the number of brand partners. So, like, where are they getting these oils from?
Mm-hmm.
He didn't really answer that.
I mean, we're haters to some, but to others, like people like you who've left, we're planting those actual seeds.
Yeah, and I disbelieved so many things when I was still in. I'm hoping that us showing the transcript on the screen and reading from it and like making it available to y'all so that you can read it and like just sit with the information is helpful for you to make your own decision. But like, this is stuff coming from Gary Young's own mouth. So I love how the lawyer called it false advertising. Me too. I think Kat and I are gonna try to do the next transcript in a few days, and we will let everyone know when the next one's gonna be on the docket. the pretend docket, because we're not lawyers. We just read transcripts over here. And I hope y'all are enjoying this. We're enjoying being able to stream together and read it and like see the tea. I've been highlighting parts of it, but some of the parts I haven't read through, so some of it's been shocking to read and react to at live.
Like you see the names, but actually reading through it.
Yeah. Yep. So live chat, you've been great. I can't wait to go back and read through the comments.
Thanks for your patience too.
After
as I continue to mute noise.
No, you're good. So live chat, you've been great. I can't wait to go back and read. Replay crew, let us know what you think. Let us know if you've watched the other videos. And if you don't already follow Kat, please go over and support her and follow her channel, like her video. And if you're new to me, hello, I'm DeeCee. I do a lot of live streams, and we focusing on Young Living right now. So I
love how often that you do live streams. I think it's really cool. And I'm in the process of finding and hiring a nanny. Whenever that is done, then I really want to do live streams more.
Yeah, no, it's we don't have any kids, so it's obviously easier when I know that kids are it's a whole new factor. It's a whole extra additional factor. So, and you have a full-time, you have a job. So it's like,
the extra time goes to the job. So
yes. Yep. That's why I do stuff at like 1:30 in the morning. So the late night live crew is like hanging out most of the time on the other side of the world. So,
all right.
All right.
Thanks, y'all.
Everybody, thanks so much. Please join us next time, and we'll let you know when we will be streaming. And have a good evening or day whenever you're watching this, and we'll catch you on the next live stream. All right. Bye.